Court is now open, please. You may be seated.
Thank you. Good morning.
SJC-11218, which Spaniol's case.
All right, let's proceed. Good morning.
Good morning. May it please the Court. My name is Kimberly Davis-Creer, and I'm here for AIM Mutual Insurance Company, the appellee in this case. The question that brings us here today is whether a workers' compensation insurer can avail itself of the fee-shifting provision contained in Mass General Law, Chapter 152, Section 13, capital A, sub 10, in cases involving claims for Section 36 benefits under the Workers' Compensation Act, which are benefits for loss of function, scarring, and disfigurement. And more specifically, another question that brings us here is what the interplay is between Section 13, capital A, and cash award as defined by CMR 1.02. Two questions appear to have arisen. The first is, does Section 13, capital A10 apply to Section 36 claims at all? And if so, has the administrative judge, the reviewing board, and now the appeals court properly applied it? In its most general terms, Section 13, capital A allows a workers' compensation carrier to withhold up to 22% of a cash award made to an employee to defray the costs of attorney's fees.
Now, ordinarily, the insurer would be responsible for paying the attorney's fees under the statutory scheme.
In most cases,
yes.
If an employee prevails at conference, the insurer would pay for the fee.
Yes,
It's only if you settle before you get to the conference that you don't pay for the fee. Is that right?
Correct. There is one instance in Section 13A, sub 7, wherein the court decides, the reviewing board decides what the fee would be. But normally, yes. In a situation where an employee prevails at conference, the insurer would pay the fee. In a situation where an employee prevails at hearing, the insurer would pay a fee.
And when the insurer accepts a claim within 5 days of the hearing,
Yes.
it is still primarily the insurer's, it's the insurer's obligation to pay the attorney's fee, except if certain circumstances are met under the statute, right?
Yes.
Which allows
Yes, Your Honor.
shifting.
Yes, if you accept a claim within 5 days of a hearing, you would be responsible to pay a fee to counsel. 13A5 does contain a provision that allows the administrative judge to increase or decrease that fee.
Which would otherwise be roughly $3,500, but it would go up or down depending
Every
upon
October.
Yeah.
It's roughly $5,600 at this point.
Okay, and let me ask you, in the appeals court opinion, in one of the footnotes, it appears that at oral argument there, the insurer conceded that the insurer had not accepted the claim. Is that right?
I was present at that argument, and I did indicate that we had not accepted the claim initially, which is what I understood the question to be.
Okay.
And we didn't. Obviously, would not have been at hearing if we had simply picked up the claim and paid the employee.
Ms. Davis?
Yes.
I'm having trouble understanding what the, I see what the statute says in the regulation. What is the rationale for this taking back from the employee, 22% of the fee? What purpose is that serving?
Section 13A10 was inserted by the legislator in 1991 as part of a major overhaul to the workers' compensation system designed to decrease the cost of workers' compensation in the Commonwealth. So quite frankly, 13A10 was placed in the statute to afford workers' compensation carriers an opportunity to get some money back, for lack of a better word, by recouping a portion, up to 22%, of a cash award made to an employee.
In return for a prompt payment?
Well, all payment, no, not in turn for a prompt payment. The payments.
But only when it's paid within a certain period of time, correct?
Well, all agreements have to be paid within a certain period of time, and it's actually 14 days.
So the 30-day period referenced in the recoupment, let's call it the recoupment statute, or the recoupment portion of the statute, that has nothing to do with
Timing?
timing?
No. It's 14 days, and and the risk to an insurer is that if you don't pay it within 14 days,
There's a penalty.
you are subject to penalties. The 30 days is the amount of time that an insurer can recoup weekly benefits from the date of a decision. For example, if an employee prevails at hearing and he is placed on benefits, 13A10 provides that an insurer can only recoup up to 22% of the prospective benefits
For that
following the decision. That's the 30 days.
Let me ask you a couple questions about this case that weren't entirely clear. Like this Mr. Spaniol got medical benefits, and I don't know what other, he had applied for medical benefits, and apparently those were not contested.
Correct.
So he simply received them for whatever period of time he received them. It was the Section 36 benefits that were contested.
Correct.
The disfigurement or, impairment, bodily impairment.
It was actually both. It was loss of function to the shoulder, the knee, and a disfigurement for a limb.
So there was no attorney fee associated with the benefits that he received.
The claim was denied at conference. So
No, I meant the medical benefits. There were no attorney's
No,
fees associated.
there was no
with-
litigation.
No litigation with respect to that.
Correct.
Maybe lost wages as well?
Yes,
Okay, so all of those were uncontested.
correct.
Now, ordinarily, with the exception of something like Section 36, and maybe there are other instances, things are not lump sums. They are weekly benefits, right?
There's a couple of different agreements. In this case, for example, at the first hearing, we entered into what's known as a Form 113, which is an agreement to pay compensation, and that was an agreement to pay him, in this instance, a negotiated Section 36 amount. So that would
Right,
be-
but I mean, ordinarily, so you're saying
Which isn't
that
a lump sum.
it's not a lump sum?
No, that agreement was not a lump sum. That was not a settlement.
A lump sum is when you take prospective payments and lump them together and pay some percentage of them at once.
The term of art down at the DIA for a lump sum is that you close out the entire claim. Indemnity, medical, if it's a no liability settlement, and 36 if it hasn't been paid. In this particular case, there was no settlement. The Section 36 benefits were paid again via a Form 113, which is an agreement to pay compensation.
But it was a negotiated agreement. It wasn't the amount of money that had been sought.
No, the amount of money that was originally sought was in excess of $20,000, if my memory serves me correctly.
So let me ask you, like, if you do what you call the prototypical lump sum, which settles everything.
Correct?
Is the attorney fee portion of that, if there is one, taken out up to 22% of that too?
No, in a lump sum, what would normally happen is, they don't have to, but normally counsel for an employee would reduce his fee in a lump sum of the entire case. Employee counsel would reduce his fee by a percentage that represents what the 36 allocation has been designated as. So it's not 22%. If a case settles for $20,000, and employee counsel chooses to allocate $3,000 towards loss of function, he would reduce his statutory fee of 20% by, he would base his fee on $17,000 and not the $3,000 that was allocated towards Section 36.
But then that wouldn't be deducted from the first 30 days under subsection 10 as here.
No, two entirely different scenarios.
All right.
This is how, in practice, you would handle unpaid 36 if you were lump summing your entire case out.
Okay.
And the 30 days that is referenced in cash award and amount payable to the employee within the first 30 days of a voluntary payment order or decision references the insurer's ability to offset monies towards the attorney's fee, but it's two different scenarios.
When you, not this case, but when you do have monthly payments, periodic payments.
Yes.
Do you take the 22% of the first month and that's it?
That's it.
So it's 20, so if that was $100, you're taking $22.
Correct.
Period.
Correct.
Even even though it may be for 3 years or 2 years or whatever, right?
In a case, yes, in a case involving weekly benefits. You can't take 22% of the retroactive award that might have accrued.
Nor of a present value of the prospective award, right?
Correct, just 22% up to 30 days.
So that's going to, generally speaking, be a small amount most of the time. You're not going to be able to recoup most of the attorney's fees that way.
Correct.
Yet in this instance, you recouped, or you wanted to recoup something like 60 to 70% of the entire attorney's fee.
It was 22%, and it was roughly $1,600 in this particular case.
$1,600 out of $2,500.
Out of a $7,600 award that we had included in the agreement.
But the $2,500 was allocated to attorney's fees.
Correct. And then 13A10 allowed us to take 22% of that.
Of the 7,000.
Correct, to be
Which
distributed
in effect meant roughly 60 to 70% of the attorney's fee.
Correct.
So when it's done in a Section 36 context, it is a significantly higher proportion of the attorney's fees that the employee has to basically pay for than in a weekly benefit scenario.
In some situations, yes, that could be the case.
Yeah.
Did Section 36 exist when 13A paren 10 was enacted?
Yes,
So that was already in effect when 13A10 was enacted.
correct.
And what makes you think that when it was enacted, it was understood to include Section 36 in view of its terms? Its reference to weekly payments would suggest that it was not.
The commissioner, as you well know, has the ability to promulgate regulations when a statute is silent on what cash award and amount payable to the employee.
Well, I'm trying to figure out, I mean, you say that the term is may reduce the amount payable to the employee within the first month from the date of the voluntary payment order or decision. But of course, what you said to me earlier was the entire amount of a settlement is payable within the first month. That is, it's required to be paid within 14 days. So it can't refer to that, can it?
The regulations?
No, the statute. The statute says the insurer may reduce the amount payable to the employee within the first month.
Right.
So the question is, what is the amount payable to the employee within the first month?
Whatever his weekly benefit would be under Section 34 or 35, depending on what he was placed upon within the first month.
But not in a 36 context. It would be the whole 36 payment, right?
Yes.
But how
That
do you
would-
get, but that's what I'm trying to figure out. Where in the language of the statute, when it speaks about that you may reduce the amount payable to the employee within the first month, does it suggest that the Section 36 payment is to be included within the framework of the language payable to the employee within the first month?
It's not in the statute, Your Honor, but it's in the regulations that were promulgated thereafter.
But you're telling me that according to the statute, all that you would be entitled to would be the amount payable within the first month of a weekly wage payment.
If you were considering weekly benefits only, but it would be our position that the regulations specifically include Section 36 in the definition of cash award and amount payable to the employee.
Okay, but you're also telling me then that the regulation is not based in anything, in the language of the statute, that there's nothing in the language of the statute which would suggest that it includes the Section 36 payment.
But I don't think that the regulations...
Sorry, is that a yes or a no? Do you agree with that?
I agree that the statute does not reference Section 36 benefits, but my argument would be that the regulations don't make that section of the law inoperable, because...
But then my question is, where does this regulation come from, if not from a statutory authority? Are you saying that there's regulatory authority to extend the scope of Section 10 to include Section 36, even though there's no language in the statute which would support that?
Yes, Your Honor. I think the case law, at least as I read it, is that the commissioner and the agency who is responsible for running the DIA does have the ability to author regulations that are binding, and those regulations are generally given due deference.
All right, and by that logic, if the regulation were to change to say that you may reduce lump sums by that same amount, that we would give the same deference to that? That basically the commissioner, by regulation, could extend the scope of Section 3810 to include even a lump sum payment?
I suppose he could. I'm not aware that he has.
I'm not actually sure that, because there's a reference to 13A 1 through 6, and I'm not sure that those would cover lump sums, would they, or would they?
No. No, that's just the statutory scheme for fees as you progress through the stages of litigation on a workers' compensation case.
Well, counsel, your time is up.
Thank you.
Thank you.
Good morning. May it please the court, Charles Berg for the employee, or actually the employee's estate. The only time an employee pays his attorney a fee is from a lump sum settlement that redeems liability of the insurer. And that's based, the fee is statutorily set as a percentage, 20% if it's an accepted liability case, and 15% if it's not. But this didn't involve a lump sum settlement of the case. This involved a claim for specific compensation. And there was a acceptance of the claim within 5 days of the hearing date. So that implicated the attorney's fee statute. And
That's 13A5 it implicates?
yes. And therefore, there was an attorney fee due and payable by the insurer. The question is, can the insurer shift onto the employee's Section 36 award a portion of that attorney's fee? Now, the statute speaks in terms of shifting a portion of the fee to the employee in certain situations, and it's set at 22% of the amount payable within the first 30 days. Now, that sounds to me like the legislature was thinking in terms of continuing weekly benefits. There's a similar provision in Section 11, capital D, sub 3, where there is a overpayment created, where the insurer has overpaid the employee. They're allowed to recoup from the employee up to 30% of future weekly benefits. So I think the legislature had that model in mind.
But only once? In other words, only from the first payment?
Well, no, until they could recoup all of it.
Okay.
But of course, if it's a low workers' comp rate and it's a big overpayment, that's not a great remedy for the insurer. And I would suggest that the limited ability to shift the attorney's fee in the provision we're talking about here was something that was intended to be a limited remedy. In a case of a Section 36 award for, say, loss of a limb, the insurer, if you take this regulation at its face, can recover back the entire amount of the attorney's fee from the employee. Now, Section 36 has been a...
Can I ask you, though, this has been around for 22 years. There are lots of workers' comp cases resolved, lots of Section 36 payments made, issues resolved. Is this the first time this has ever happened? That the insurer has netted out the 22% or whatever?
No, it's not the first time, but I hope it's the last time. We've been before this court in two other cases, which were...
on this issue?
Not this court, but the appeals court. On this issue, yeah, they were resolved by Rule 128.
The Vaughn and Grogan, those two?
Right, right. But this is the first time that the regulation has reached this court. And Section 36 benefits have always been subject to protective oversight by the department. The attorney's fees, attorneys cannot charge a fee if they negotiate a Section 36 award. This is an award that is a one-time payment to an employee for a loss of function or impairment or disfigurement that theoretically would affect their ability to find work in the future. It's the only cash award of its type in the department. For instance, if we, as my sister alluded to, if we settle a case that's in which liability has been established and there is reason to believe that the employee has a 36 claim, then a portion of the lump sum would be allocated to the 36, and the administrative judge or the administrative law judge who's ruling on whether the settlement is in the best interest of the employee would not allow the attorney to charge a fee on that portion.
Well, then, if that's, I'm sorry, well, if that's the case, why does this settlement provide for a $2,500 attorney's fee?
Well, because this is the Section 36 claim was contested. In other words, we had a doctor saying that this is the loss of function, 40%. They had a doctor saying, no, it's only 10%. So it was going to go to a hearing.
But I thought you said that Section 36 you couldn't have attorney's fees on it.
No, if it's not contested. I mean, if we negotiate, often, most of the time we send a medical record to the insurer. They say, oh, it sounds reasonable, and they pay the claim. So in that case, there is no attorney's fee that could be charged, that would be allowed to be charged. It's only when the claim is contested and we get into 13A, which provides for a fee if they don't pay within 21 days, another higher fee if it goes to conference, another higher fee if it goes to hearing, et cetera. So that was a situation here.
But at some point you negotiated a settlement, and so I just am kind of curious, what would have happened if the settlement agreement specifically referenced 13A 10, one way or the other?
Then it would control.
Could you in fact make such an agreement that that the attorney's fee is $2,500, but under Section 13A10 only $30 will be taken out of the or whatever, or
if Ms. Creer had called our office 6 days before the hearing and we negotiated, there would be no fee due.
Mr. Berg, I didn't hear the second half of something you said a minute ago. If there is a contested claim involving Section 36 benefits, who pays the attorney's fee? Is that paid by the insurer, or is it a percentage of the recovery?
It's paid by the insurer. If the employee, for instance, prevails at a conference and no one appeals that conference order, then it would be 13A 3, I believe, is for conference, and it's a set amount. It increases each year with the cost of living. I think it's now about $1,600. If, for instance, the conference order is appealed and it goes to a hearing and the employee prevails, either by getting a better result at the hearing or the insurer agrees to pay within 5 days of the hearing, then there is a fee that would be payable by the insurer to the prevailing employee's attorney.
Above and beyond the Section 36 award?
Right, correct.
Okay.
but
So
here you negotiated the fee, right? Because it
we
was otherwise
negotiated
it would have been
everything, sure.
it would have been a $3,500 fee at the time, right?
Well, it would have been more than that. 35 is what was set when the statute was enacted. Now it's up to around 5,600.
All right, so whatever it was, you agreed to a lesser attorney's fee.
Lesser attorney's fee, and the amount of the Section 36 benefit was
Was
negotiated
also less.
as well.
So,
it's-
but it didn't reference 13A10 in any way.
No, it didn't. So
And was this approved by an administrative judge?
it had to be approved, yes.
And the 13A10 piece didn't come up?
Apparently not, no. It could have been negotiated. It could have been, you could have stated, and there will be no offset under 13A10. But that wasn't done, so the insurers said, well, 13A10 is at play here because we paid a fee. We accepted the case within 5 days of a hearing, and technically they're right if that regulation applies to Section 36 benefits. We say the regulation is spun out of whole cloth by the commissioner. It has no basis in the statute, and it unfairly shifts to the employee the cost of the attorney's fee that under the statutory system should be borne by the insurer.
Is that in all circumstances involving Section 36, whether it's settled or unsettled?
Well, again, there's no fee due an employee's attorney if it's not within 13A, that is, if it's not being contested by the insurer. If we file a claim for 36 and they send a check, then good for the employee, but his attorney isn't entitled to a fee.
When was the regulation promulgated? Was it, I mean, it was before the Sullivan case, because the Sullivan case says we leave for another day, whether 36
Correct.
is at play. So I just wondered whether the when was the regulation? Do you know?
No, I would, it was after the 1991 revisions to the Act. I believe that's when the fee shifting section sub 10 of 13A came in. So it would have been after that, of course. And
you say even if it applied, you should sort of allocate how much of this goes for a month. I mean, at the end of, it's your fallback argument.
right.
The problem with that, though, the first piece of this, it works for the 39 times whatever. I take it the 39 means weeks.
Right.
But the other two don't have weeks associated with them, so you can't really do that, which may support your view that 36 shouldn't be covered at all. But isn't that right? I mean,
That's right. I mean, the way the 36 award is, for instance, if you lose a shoulder, it's 39 times the state average weekly wage that's in effect at the time of your injury. So my suggestion as purely fallback is if that's how Section 36 benefits are computed, then that's a weekly unit that you could use to determine what the 22%
for the month is.
Right, yeah. So.
But all I'm saying is it doesn't work for all of these injuries, at least as you settled them, because not all of them seem to have that times 39 piece to them. Some of them seem.
Well, I think most of them do. I think the scarring, disfigurement, they're measured, by inches times a multiplier.
Oh, okay. That just isn't
so.
it isn't in the piece of paper, but that's okay.
Yeah.
All right.
But you're right. I mean, our argument is that Section 36 is something that has been traditionally protected by the department for the benefit of the employee, that the statutory scheme provides for some means for reducing costs to the employers by allowing their insurers to recover modest amounts. The recoupment situation in 11D, and I would suggest here, as regard ongoing weekly benefits, to shift part of the attorney's fee. Never do I believe the legislature intended that Section 36 benefits be pulled into that attorney fee
Speaking of what the
shifting.
legislature intended, is there a legislative history that gives us an idea of what they were thinking?
I couldn't find anything specific to this 13A10 other than it was part of give and take to try to reduce the overall cost to employers in the Commonwealth. And at the same time, as part of that 1991 legislation, there was reduction in the weekly benefit for total incapacity from 66 to 60% of your average weekly wage. And there were reductions in or changes in, for instance, disfigurement benefits. It had to be only below the wrists and neck and face. It had to be visible to be compensable if it's just based on scarring. So there's give and take, and I would think that if they wanted to create a means for the insurer to get back the entire attorney's fee, say a hearing fee of $5,600 on from a award for an amputation of an arm, then I think there would have been more specific language in the statute. And certainly the statute itself is talking about within the first 30 days of the a voluntary payment order or award is talking clearly about periodic payments, because every payment has to be made within 30 days. The Sullivan case, the reviewing board said to the insurer, no, you can't include the retroactive award as part of that. And I think they got it right, but I think that they felt hamstrung by the Commissioner's regulation that defines, that pulls Section 36 into this. And I don't believe there's any basis in the statute for him doing that. I think it exceeded his authority, and I ask that you annul that
Now, am I
regulation.
correct that the one thing which you and your sister agree upon is that we should not do what the appeals court did?
Correct. The appeals court got hung up on whether there was a settlement or a negotiation. They missed the point that it was within 5 days of the hearing and triggered the 13A fee structure. So,
Well, counsel, we have to leave it there. Thank you very much.
thank you.